Welcome everyone. I'm really excited about this conversation and I'm happy that you all could join us today, tonight, this morning, whatever it is, wherever you are. So this conversation is something that, I think some of our panelists and I have been having in different forms over the last several years. And so I'm thinking of this as a way to invite you all in to a conversation that we have where we kind of throw around ideas about what's changed, what's new, what do we need to know from a litigation perspective, what kind of forums are available to victims of transnational human rights abuse by corporations, and how does that change year to year? So this is kind of our 2021 update, what's new, what do you need to know to understand the landscape here? So being the only person from the US and not being on the panel, I'm going to abuse my moderator privilege for just a moment to say, for those of us here in the US, the context here is obviously the Doe v. Nestle case. I think a lot of folks have followed that. The Alien Tort Statute, as something that has been very much embattled for many years now, took another hit, or arguably not a hard hit, but a hit in the Nestle decision that came out in July. In this case, the Supreme Court of the United States said that there was insufficient domestic conduct related to aiding and abetting child slavery in Cote d'Ivoire, which is what the case was about. So this is a decision that in some ways doesn't change the landscape that much in the US because the Alien Tort Statute was already in rough shape since the Kiobel case and the limitation on extraterritorial application of US law. But I think that it did some good things in the sense that we now know that we probably have 5 justices that would support corporate liability under the Alien Tort Statute. We don't have a vote that is clear on that. We have some interesting dicta to that point. So that's kind of helpful. We know that we still have the trafficking statute, which has extraterritorial application and corporate liability. We do have the torture statute, which has extraterritorial application, but no corporate liability. But overall, the big fear that people in Congress and folks internationally and domestically had about the United States becoming the world police because of the Alien Tort Statute does not seem to be becoming a reality. And in fact, the United States is maybe offering less of a forum to victims of human rights abuse than several other places around the world. So situating us there as a space of maybe shrinking opportunities domestically, although there are still some, we wanted to have this panel to think more broadly, looking at this from a global perspective. Where can a litigant go, a prospective litigant who has suffered a human rights abuse where there is corporate complicity or responsibility of some form? Do they have anywhere to go? And what does that look like? And what are those limitations? So to discuss this, I'm bringing together 3 panelists. One of them is going to be late, so I'm going to start with her. Miriam Saage-Maal is a lawyer and legal director at ICAR, where she's built up the business and human rights program. She's worked on various cases against corporations, including civil proceedings against German retailers relating to the exploitation of workers in Bangladesh and Pakistan, and against companies trading in cotton picked by forced child labor in Uzbekistan. She regularly publishes articles on the questions of corporate accountability for human rights violations in the global supply chain, and she consults internationally as an expert in corporate responsibility and human rights. So she's going to bring a lot of European perspective to this conversation, but she will be here in about 20 minutes, so we'll bring her in when she gets here. Second, I have Dan Leiner. He's a partner at the UK law firm Leigh, which many of you are probably familiar with. He specializes in international human rights and environmental law with a particular focus on business and human rights. He has extensive experience of cases against parent companies, complex group actions, and mass tort claims, as well as cross-border disputes and jurisdictional issues. He has extensive experience in Africa and has lived in Kenya and Congo, DRC, where he worked with local lawyers on strategic litigation and access to justice issues. And last but not least, I have Gabriel Pereira, who is a founder and president of the human rights organization Andes, and a permanent researcher at the Consejo Nacional de Investigaciones Científicas y Tecnológicas de Argentina, and a human rights professor at the National University of Tucumán. He's an affiliated researcher to the Latin American Center of the University of Oxford. He has a PhD in politics from Oxford, a master's degree in social science from the University College of London, and a law degree from the National University of Tucumán. He's written in journals and in books on fields including transitional justice, business and human rights, and judicial politics. So really awesome panelists. Before we get started, I'm just going to flag to you right now that I'm going to give you a really short amount of time for questions. So as you start thinking now, as we go through all of our discussion here, as questions arise, I'm going to put them in the chat. And at the end, there's going to be one round. I'm just going to read off the questions in the chat in one round. I'm going to give my panelists a chance to respond to all of them and whichever ones they choose. And that's going to be it. So don't wait till the Q&A starts and then kind of like slowly think about whether you want to have a question. You're going to have one chance. So I'm just giving you prior warning. Okay, so to start us off, let's start with Gabriel. So Gabriel, you published a book recently called Transitional Justice and Corporate Accountability from Below. So based on the research that you conducted for this book, tell us where most cases are being filed. Did you notice any trends or recent changes in types of cases, be they civil, criminal, administrative, consumer protection, et cetera? Any trends in location of harm or country where cases are being filed? Give us kind of the big picture overview of currently what is happening in this space.
Hello, everyone. Thank you very much, Charity and ICAR and the audience. Okay, straight to the point because of the time. Basically, we with a couple of colleagues, we wrote this book, and we focus on only cases related to blow crimes. Yes, so in that sense, we restricted our research, and what we found is that 70% of the cases that has been litigated related to these crimes in transitional justice context has been happened in Latin America. So most of the cases that we found that are related to crimes committed in Latin American countries, opposed to 18 in Africa and 17 in Asia. And more than 60% or around 60% of those cases have been litigated in home country. I'm sorry, 70% of the cases, or 75% of the cases in Latin America have been litigated in Latin America. So what we find is that at least in this topic, there is a lot of protagonism of domestic courts in Latin America. We find that most of there is some kind of country concentration in Argentina and in Colombia, where we find the most the highest number of cases. In terms of the type of cases, most of them are criminal. That's you can understand that in terms of how transitional justice mechanisms have been working in Latin America. You know that criminal prosecution are kind of the most protagonist or the preferred mechanism. So most of the cases are criminal cases. We have found some kind of innovations in terms of what we call truth trials. Truth trials are those cases, the trials where you can do some prosecutorial investigation, identify the person who committed the crimes and also the victims, but you can't sanction them. That's something that was created in the 90s by Inter-American Commission of Human Rights. We have a kind of truth trials, the Volkswagen case in Brazil. We can discuss that later. And we also found some kind of innovation in terms of labor law cases. So these are non-criminal, non-civil, and those are, we have 3 examples from Argentina. One of those examples is a final conviction, and then we have another case which reached the Inter-American Commission of Human Rights. And in terms of criminal litigation, usually the preferred legal strategy is to go for secondary actor or participation or complicity. We can discuss also that later, but we also find some innovation in terms of money laundering, where we add to disappearances or torture and this type of crimes, the money laundering crimes, which is very interesting. We don't have conviction there yet. And we have in Latin America very, very few cases, actually 1 case or 2 cases, where there is the prosecutorial strategy was directed to show the direct participation of the accused. That's a case, for example, the case of Lusoro in Chile, where the accused was found guilty of committing torture and forced disappearance, and he directly participated, not as a accomplice, but as a primary agent. And the last thing I can say is that what is interesting about Latin America is not the concentration, not only the concentration of cases, but the number of pending cases. So what we see is that there is still an ongoing litigation process, you know. So that opens it. We can discuss also later. We have seen like a stop motion pattern of these cases. These cases move in the accountability continuum, but in a very, very slow mode. So there is this kind of high level of pending cases is good because you bring some hopes that accountability could happen. But on the other hand, when you look at these cases, we see that those pending cases have been pending for more than 4, 5, or 7 years. So that's something that we have to look at. And particularly, that's interesting for practitioners. The last thing that what we see is that still civil litigation is still something that is very, very unexplored in the region. There are many reasons for that. And one of them is that this transitional justice inertia, let's say, where criminal prosecution is the type of justice that you can get. And there is some kind of discussion there also among human rights organizations about whether asking for financial reparation is ethical or not in terms of human rights cases. But that's a very, very quick overview of what we have in our book.
Great, thanks, Gabriel. That was really helpful. I have a number of things I'm going to want to follow up on, just flagging them right now, that I think that this sort of tension between civil and criminal litigation, both strategically thinking about what is more advantageous for potential for victims who might want to bring a claim, but also thinking about just what's possible in each jurisdiction. I think we should come back to that in a few minutes. You know, also the idea that 70 to 75% of Latin American cases have been litigated in Latin America is really interesting, and we'll come back to that as well. But first, Dan, do you want to tell us a little bit about the UK? There have been very exciting cases in the last few years in the UK. I know a lot of folks internationally are looking at the UK as, you know, the sort of most favorable forum for certain types of cases. Tell us about some of your recent wins and how we should view the UK as a forum for transnational human rights cases.
Thanks, Charity. Great pleasure to be with you this afternoon here, morning where you are. So I'm at Leigh, which, for those of you who don't know, is a law firm that has brought a lot of these cases in the UK, pushing the boundaries of the common law as civil cases, civil damages claims. And these started in the 1990s, where they developed through jurisprudence, which went up to the Supreme Court back in the 1990s, early 2000s, the concept of parent company liability, which is a concept in tort law, common law torts, which is basically says in certain circumstances, if the parent company is sufficiently involved in the actions of the subsidiary, which directly cause the human rights abuse or environmental harm or the occupational health problem, then there's no reason why in principle it could not also be held legally responsible. And if that is a UK company, no reason why you can't sue in the UK courts. Now that concept, although it was established in broad terms in the 1990s, it was then challenged head on by the multinational companies who all got together and instructed common legal teams. And we had 3 cases that have been going through the courts over the last 5 years. One case against a company, an Anglo-Indian company, mining company called Vedanta, another against Shell for oil spills in Nigeria, and a third against Unilever to do with their tea workers in Kenya. And the process culminated in 2 unanimous Supreme Court decisions. It went all the way to the Supreme Court, the most recent of which was handed down last year, which basically totally rejected the multinational company's attempt to really limit and restrict the scope of this liability, and in fact ended up expanding the scope of the liability and said, actually, there's no reason in principle why parent companies can't be held legally liable or responsible for harms committed by their subsidiary. And it expanded the basis upon which that liability could arise, including, very importantly, through the global policy framework of the multinational company. It says, look, if that global policy framework is detailed and relied on, turns out that it's flawed, then there's no reason why you can't seek redress in London against the parent company. So this is, for most multinationals, this is total panic station territory, because they weren't anticipating the Supreme Court would go so broadly. And where we've now ended up is the conditions for bringing these cases in the UK are much more favorable than when the counterattack of the multinational companies started. I mean, I won't get there. There's other cases I could talk about. There's also another case to do with shipbreaking, where called Begum and Moran, where the Court of Appeal in that instance said that actually there's an arguable duty of care on companies if they are selling their ship to a third party, which ends up committing harm to another. So in that instance, it was this shipping company that simply sold its ship to an incredibly dangerous shipbreaking operation in Bangladesh, and one of the workers ended up dying because there was no health and safety. And we sued the ship company, the English ship company, and the Court of Appeal agreed that there's an arguable, when it's that foreseeable, that if you actually sell your goods or your services or your assets in a way that's actually going to create harm to individuals, even though you've got nothing to do with it, you are potentially legally liable. So all in all, I think we're going through exciting times in the UK. We've also got challenges which arise out of Brexit, which we might touch on later, but there's now a lot of civil litigation going on. We're doing most of it, but there are other law firms, some of whom are also very good, who are now getting into this space, because it is seen as no longer kind of fringe hippie lawyering, which it was for many years. This is seen as mainstream, credible, well-trodden law now. In a way that, in many other jurisdictions, I think for various reasons, it's not as developed yet. So yeah, I would say very positive mood music coming out of the courts in the UK on civil liability for multinational companies.
Thanks, Dan. It's very exciting. I think a lot of us in the US thinking about sort of trying to push the common law domestically through like state law claims, it's certainly, it has been tried, it's being done, is really hard. And I think that the sort of big wins that you all are experiencing have not been reflected here domestically, but it gives us something to aspire to. So, you each have talked a little bit about, bringing cases in the jurisdictions where you live, but also more broadly. So let's think about this specifically. I'm a potential litigant and I'm thinking about, I've experienced this harm and I'm thinking about where I want to bring the claim. I recently read this really interesting article on delocalized justice, which raised this question about, it had some critiques of using foreign courts to bring a claim. So this idea that the harm occurs in the global South, you use a global North court, probably where the parent company or some related company is at home. And so there's some critique of this suggesting that there are losses by not litigating things within the home state. We also know that historically there's been a lot of issues with security, corruption of local courts that have been obstacles for some human rights victims to bring in cases in local courts. But as Gabriel pointed out, 70 to 75% of these Latin American cases are being litigated within Latin America. So maybe let's go to Gabriel first. What do you think? Should folks be trying first to bring cases at home before they go? And should cases abroad be like a last recourse? How should we view this?
That's a very interesting question, and the debate is really, really necessary. And that based on our evidence, the cases that have been more successful, and I will give you some idea of what I mean by successful, did occur in domestic courts, not in foreign courts, you know, the kind of the North court that you were mentioning. So what we see is that the litigation processes are happening in Latin America, and they are providing some good outcomes. And that's what we discuss in the book. We discuss how these processes are taking place. The thing is that there are some conditions where you can see those outcomes could happen, you know, and you need to think about not only strategic litigation, but you need also a strategy to increase civil society mobilization around the cases. And we can discuss many of the type of civil society mobilization. But for example, let's think about the Ford case in Argentina, the Volkswagen case in Brazil, or the Lusoro case in Chile. Those are cases where you got some kind of positive outcomes. You know, convictions that are final conviction or conviction under appeal, or this kind of disagreement between Volkswagen and workers. There you had a very, very strong civil society mobilization in working together with these strategic or institutional innovators from civil society, you know. But the second element that we found that is necessary to get some level of accountability is to get these kind of institutional innovators from within the state, you know, those public prosecutors, judges, or executive agencies who participate in the litigation process, who brings new or pushing or lead these cases, you know. So, and there is some ways to map and identify whether you have institutional innovators or not. And then the other condition, which is really interesting, is the type of veto powers that you have. You know, we assume that the defendants, the accused, are the veto powers of accountability process or judicial accountability process. But then we found that there are not only those, but also other economic actors or government who are part of this kind of block of veto powers, you know, those who are able to block this accountability effort. So we are not seeing in the world many cases. It's easy to go and see to the ground how these processes are happening. So yes, I would agree from an empirical point of view, and what we saw so far, that domestic litigation is being more successful than foreign litigation in terms of accountability. We still have to see what Dan said about what could happen in the UK, and that's very interesting. Also, we are seeing something that is at least changing in Latin America, but I think that it might change in the UN system, is that there is a more firm or more direct message from the international human rights agencies that government have a duty to prosecute this case and to promote the prosecution, or to make access to justice something real in the country. So that's another element that could help domestic litigation, because at least in Latin America, you might know, there is some kind of the Inter-American system have a very strong say in human rights issues within countries. So I think that in general terms, yes, I agree with what you said before, but it's not an answer in principle. You know, it's what the data says, and we know that things are changing, and there are a lot of new developments, and we are very anxious to see how things turns out in UK, for example. but in general terms, yes, I think that I'm sorry. And one important thing that is that when we say some level of accountabilities, we think that for analytical purposes, what we try to map accountability not as a binary, no accountability and full accountability. What we try to analyze different levels of accountability, and what we try to do is to map all the cases and situate in a continuum of accountability. And you see that these factors that I was mentioning interact in different ways depending on where these cases reach. We have no accountability and full accountability when the conviction is final. There is no appeal further. So that's something that we could discuss later.
Great, thanks, Gabriel. It's a good pitch for localized justice. I think, just pulling out something that you mentioned about local mobilization really highlights the importance of viewing litigation as one tool in a broader tool set, and that it's not something that stands alone. And I think that any of us who have litigated also very much understand that if a community that you're representing is not organized and doesn't have some sort of ability to speak with a collective voice, it is very difficult to adequately represent that community and their needs, because if they're as diverse as they are individual people, it can be really hard to address some of those more collective harms rather than just individualized harms. And I think this localized versus delocalized justice question does really speak to that and some of the difficulties of bringing cases in a delocalized way. Now, Dan, I know that Leigh has certainly made a name for itself in a more delocalized justice way. However, I also know that Leigh has worked with local attorneys to bring cases or work on cases within local jurisdictions. So you do actually bridge that. You can respond to this question by making a pitch for delocalized justice or something more nuanced. It's up to you. Go ahead, Dan.
Well, I mean, I don't think there's any disagreement, any debate as far as I'm concerned here, because clearly if localized justice is achievable, then it's a no-brainer. You must go through the local courts. It's much better to get local justice. The only reason Leigh internationalizes cases and takes them to the UK is if it's impossible to get justice locally. And I'm fascinated by what Gabriel says about his book. I mean, I'd very much like to read those. Unfortunately, in many parts of the world, the idea of an impoverished community taking on the might of a multinational company is entirely illusory. It's a total non-starter. So I don't know, to give you, I have so many examples, I don't know where to start. Shell, Niger Delta, oil spills. It's essentially there is total impunity in Nigeria for oil spills. There's never been a case where Shell has been forced to clean up its oil. It takes on average 25 to 30 years for a case to go through the civil justice system, by which time everyone involved is dead. And if there is an award of damages, it's generally peanuts, and it goes to the lawyers and the chiefs. Two cases I've done a number of cases against diamond and gemstone companies and agribusinesses, human rights abuses committed by guards against local community members. In all those cases, without exception, the local communities are absolutely terrified because of the power dynamic of taking on the multinational company. And so they say the only way we are willing to stick our neck out here is if we go to an international court. You ask them, do you want to bring a case in Kenya, Mozambique, etc.? Absolutely not. They know it would be a certain death in many cases for them to do so. The protection for them is to bring a case in an international forum. Where it is changing in some jurisdictions. So, in South Africa now, you can bring these cases. And we now work with local lawyers in South Africa to bring complex group actions. And we're doing a case suing Anglo American now for leaving an environmental disaster in Zambia in one of its historic mines, the most polluted town in Africa, called Kabwe. And we're suing in Johannesburg with local lawyers there. And I think that will grow. I think, you know, in the next few years, you could envisage cases now being brought in Kenya. But then in some, for example, but we're a long way off for a case being a viable option in a country like Congo DRC. I know the legal system there. I've lived there. I've worked with lawyers. I know what it's like. The idea of taking on the force of a multinational company is not going to happen. So then the question is, where do we go? Do we just sit back and allow multinationals based in our jurisdictions to simply reap the profits and live with impunity with regard to human rights abuses, or do we try and hold them to account? And that's basically where we come from. We will always try and work with lawyers to sue locally if possible, but if it's clear it's not possible, then we'll bring the case internationally.
Great, thanks,
Sorry,
Dan. You know,
can I say something?
Quickly, though, I want to bring Miriam in because she's just joined us. But yeah, go ahead, Gabriel.
Okay, I'm totally agree with Dan and the way that he phrased his response, and I think that there are some scope conditions for accountability. And he mentioned Kenya, Nigeria, Mozambique, Congo DRC, and that's where you don't find high level of civil society mobilization or legal mobilization, and that's totally, I agree. And I see these cases as part of transitional justice. And during the 90s, many human rights organizations from Latin America decided to bring cases in Italy, US, Germany, France, Canada, because we knew that it was impossible to achieve justice in our countries, you know, and these were state actor cases. So I agree with you. There are some scope conditions where that's why I said we see that the high level of concentration of cases are happening in Latin America where you find this scope condition. And I totally, that's the reason that I don't have an in principle answer for that, because my orientation is we need justice, and you get justice whenever you can get it. You know, universal is like a universal jurisdiction. So I totally see, and that final word, I see that in Latin America, for example, is much more difficult to get civil litigation, good positive civil litigation outcomes compared to criminal. So I think that even in Latin America, thinking about foreign courts in the global north, for civil litigation is quite an important strategy. Actually, we are discussing in my organization about that. Even we know that we could bring criminal cases, we know that the civil litigation is foreclosed right now in Argentina. So we might go, even though that we have this civil society scope litigation, scope condition going on, we think that we might get to the UK or any other jurisdiction. Sorry.
Great, thanks, Gabriel. I mean, I think this idea that, you know, we don't live in a perfect world and we can have our critiques, and I think it's important to have those conversations, and also we should use whatever we have, because this is really a very hard uphill battle. I think that came through clearly from both of you. Miriam, I want to bring you in here. So I'm sorry you missed your introduction. We've been talking about a lot of sort of meaty issues. One thing that we've been sort of trying to do is lay out a little bit in each of our jurisdictions, like what's possible. So could you tell us a little bit, you know, I realize Europe is not entirely a monolith, but across Europe, to what extent are we seeing successful civil litigation, criminal litigation? If I'm a possible human rights litigant, where should I look, and what are my best chances, and what are the most recent cases that I should know about?
Yeah, thank you. Thank you for having me. So I think traditionally, continental Europe, at least if you look into, well, again, continental Europe has many different jurisdictions as well. But let's say if you take France and Germany as exemplary continental European jurisdiction, then I would say traditionally the more natural route to go is criminal liability. And that is also what you can see in the cases that have been brought, in particular in France, where Sherpa is very engaged, and other lawyers, but also where we have been cooperating with Sherpa on a number of cases. but also in Germany. While it has been our strategy since around 2015, I would say, to also focus deliberately on civil litigation, because while it is also traditionally, if you think about how is conflict being solved in society, it's not private enforcement necessarily, but it would be going to the state authorities to solve conflicts in the first place, and there may be a touch civil liability to a criminal case. Anyways, we felt at ICAR it's necessary to also test the civil litigation routes, and that's what we did. So we've done a first civil litigation against the German textile retailer in the Ali Enterprises case. And so to some extent, you can also say, obviously, continental European jurisdiction also work with civil liability. I think the question is how to make them affordable and workable for lawyers. But that's a bit of a different question. In terms of jurisdiction, there's no problem. Applicable law is pretty much the same as you have in the UK. It's regulated by the EU regulation Rome 2. And then in France, I think at the moment there you would see the most interesting developments. One, because of the momentum the criminal justice system has gained with regards to criminal accountability. So the case against Lafarge that Sherpa and we have been bringing, where we have been testing the concept of aiding and abetting international crimes on a corporate actor, and as France has corporate criminal liability, it's actually also a criminal investigation against the corporation as such, in addition to individual managers. And this case has now been heard before the Supreme Court, and the Supreme, it's on the challenge of the indictment by Lafarge. So it's not the case is not on trial yet, but the indictment was challenged, but the Supreme Court upheld this indictment and said it's completely legitimate to argue for aiding and abetting crimes against humanity in this case, and to be attaching liability to the company. So interestingly, you can also see then you have another procedure that has been gained some traction. That's a case on surveillance technology, also in France, and criminal complaints that have been filed on the question of labor exploitation of Uyghurs in Western China in textile industry. Again, also investigations have been opened. And we have been pursuing our strategic decision was to similarly go specifically to the German war crimes unit on cases. We also brought cases on surveillance technology and on the Uyghur case. Here, the German authorities are still much more reluctant than the French to look into this. Another interesting route where actually yesterday it was decided that it also definitely is the civil courts that have competence are the cases that can be brought under the French loi de vigilance, which is a mandatory human rights due diligence laws that is sort of a twofold process. So in the first place, you would go and ask the company to improve their due diligence. Well, the French don't want to call it due diligence. So their their plan de vigilance to improve it so that the rights violation is ended. That's the first step. And then if the company doesn't do it, then you can go to civil courts, and the civil court is then supposed to order that. And then if you are able to show causality between the violation of the due diligence obligations of the company under the French law and a harm that has occurred, then you can also take the classical tort route. And so I would say that, like in Germany, there has been also now, I would say, comprehensive mandatory human rights due diligence law has been implemented. It has its weaknesses for sure, but it has an interesting administrative route, which again is a very specific German idea that individuals have, can bring administrative claims, asking with specific asks to the governments as to how they should be handling their harms. I think what I would be hoping for, for the future, is that there is actually that the successes that are being achieved in different EU jurisdictions, that we would actually create more, and I think we are all thinking about this and working on this, that we create more synergies between this, because I think the jurisprudence that Dan and others have managed to litigate in the UK are potentially relevant for civil litigations done in other EU countries because of the Rome II regulation. And so I think, thinking about it, I think there are a number of opportunities. We are far from having an ideal jurisdiction, but I think the number of opportunities to litigate has really grown in the last 10 years.
Great, thanks, Miriam. So we are getting close to time. We need to shift over to a Q&A. Anyone who has a question you want to put in the Q&A, it's speak now or forever hold it. I'm not giving you 2 chances. Put it in the chat if you want us to answer it. I'm going to go ahead. I had some other really good questions that I wanted to ask you all. So here's what I'm going to do is I'm going to just tell you the basic themes of the other issues I was hoping to tease out if we had time, which we did not. Then I will also read the questions from the chat, and then I'm going to give each of you a couple of minutes to respond to any of those that you feel most moved to respond to. So my issues that I wanted to hear more about, one, I feel like there has been a real shift in some jurisdictions in the way that courts are viewing social auditing and social auditors. To what extent are companies able to use social auditing as a way to shield themselves, or now is it actually becoming a liability? I'm interested if anyone has thoughts on that. I know Vedanta speaks in some ways to that. Another question I had is about consumer protection cases. So getting out of this criminal civil dichotomy, but thinking also about other types of cases. Here in the US, a lot of folks have tried different types of consumer protection cases that obviously would not get reparations for human rights victims, but could potentially deter corporations from misleading consumers about their supply chain practices. Those have largely not been successful, with a few kind of small exceptions. We actually, as Corporate Accountability Lab, next week are going to be a plaintiff in a case against a social auditor and a brand under consumer protection and false advertising theory. So we're still trying things, and there'll be more information about that later. But it seems like it's something that is very difficult. However, there's the Lytle case, which I think is maybe a recent success in this area. So I would love to hear a little bit more about that, and in any other jurisdiction, whether folks see potential for consumer protection cases. And then the last one that I wanted to raise, and then I'll go to the chat here. There is a recent report that I posted in the chat from the European Coalition for Corporate Justice called Suing Goliath. It's a great report, but it's one thing that it says, and it's just looking at European jurisdictions, but it says it's worth noting that of all civil proceedings identified, only 2 have resulted in judgments favorable to the claimants. No final judgment has ever ordered an EU company to pay compensation for damages. This speaks to Gabriel's earlier point that a lot of times we think about successes as a win in court, but to what extent are our cases actually resulting in reparations for victims or other types of real success that change victims' lives, as opposed to just we won at this stage and then it's appealed and we go back down, or we win sort of on procedural levels. And then from the chat, I have what future do you see in the Hague rules for on business and human rights arbitration? And this is a lot of questions. Just take your little notes and pick your answers. Gabriel, and another one is Gabriel mentions critiques of monetary damages for human rights abuses. I think this is interesting too. If there's time, we'd love to hear panelists speak more to that. So there's your 5 or so questions. I'm going to start with Miriam since she's gotten the least airtime here. We have, if we're going to squeeze the end, I say we have about 8 or 9 minutes total. So 2 to 3 minutes each. Miriam?
Yeah, so on social auditing, I'm not so hopeful as you are. I think social auditing is alive and kicking. And I do think that companies will keep on using it. And I think the danger is even more with upcoming human rights due diligence legislations. I think that we have good arguments to say that you can't rely on it, but I don't think that this is the battle is won there. Consumer protection cases, yes, they are interesting, but I think, but there's in my opinion, there's a big but, right? Because who is protected? It's the consumers against what? So, that we are cheated into believing, labels that we probably don't want to believe in the first place. Anyways, I think it's legitimate, and it's a good idea to challenge this whole concept of, because it challenges also auditing, it challenges certification and the reliability of those, no? And also it shows that there are no easy ways into sustainable consumerism. So I think that's, but I think one needs to understand. So this is why I do feel that, yeah. But you do reinforce the idea of it's a consumer that needs to be protected, no? And it's not the people that are actually being exploited that need to be protected. We've been bringing a bit of a different consumer protection case. It's a product liability case. We're representing Indian farmers in Swiss courts. And these Indian farmers were poisoned accidentally by using a pesticide. And we're saying, well, this pesticide is a defective product. They are the consumer. And so they're suing under Swiss consumer law. We're waiting for the first hearing on this, hopefully soon. But I think that's also another twist where we at least make the people that are suffering from the product in the global south, make them the consumer to be protected and not us. Yes, on monetary damages, of course, it's always a problem, right? I mean, of course, it's not, yeah, you know, Saida Khatun, one of the claimants in the civil litigation in Germany, of course, he said, well, the money is not going to bring my son back, that's for sure. At the same time, those families, and you could see this in Rana Plaza and so on, they have serious losses. So it's not like, and most of the time it's, I mean, I also felt like it's not like they have much of an option. If they can gain compensation, that is something that's going to help them. Now, I am the last person to tell victims how they should define justice for themselves. And if people say we simply don't want civil litigation, well, then we shouldn't do civil litigation, right? So I do think there are very different understandings and concepts. What I do know is, while the litigants in the Pakistani case were very clear, we are doing this for justice and not the money, they still felt that they actually won the case, although they lost it in court, but they won it because the company was forced to pay in a parallel proceeding with the ILO an additional $5 million to them. And that made them feel successful because they felt we had power over them. They were represented also in the ILO themselves. They were in the ILO compensation discussions. And so they felt like, well, we used all tools to have the best possible strategic positioning of ourselves, and we've won something. And they clearly knew that money is not going, to solve the issue. And of course, they also know that KIC is not, it doesn't matter if they pay 5 million or not. Again, for them, I do believe that it made a sense, and I've also published a whole book about this, where they also speak about it. Well, they speak about it, not I do speak about them. They speak about this. So, I think one needs to have a nuanced perspective on this. And obviously, law will never bring, we all know, law is imperfect.
Great, thanks, Miriam. I wish we had another hour. I'm going to switch to Gabriel and then Dan. Gabriel, I'm just going to warn you, there's something at 10:30 that starts that I have to be at. So if we could really try to keep it to 3 minutes or less.
Okay, just very quick. Related to the human rights debate, the debate on human rights organization and practitioner about getting civil reparations, there has been a history of how you approach these cases. Crimes against humanity are pushed by the sake of justice, memory, and truth. So there is very, very strong opposition from human rights groups, traditional human rights groups, to bring these civil claims, because you are asking, for civil damages. Actually, for example, those lawyers who work in human rights trials of this type, transitional justice trials, they don't get paid for that. They don't even claim for the accused, the convicted, to pay their fees when they win the cases. So that kind of level of strong debate. So many organizations are reluctant to think about civil litigation or damages because of that. That's the debate. The thing is that we know that if we insist in criminal litigations, the perpetrators are going to die very soon. That's because the tragedy in our country happened decades ago. So that's the time is working in that way. In terms of this, the question about civil litigation and good outcomes, I think that in countries like Argentina, the clause are not closed right now, but there is a strong obstacles. In Argentina, we have two ways to avoid criminal litigation, labor damages and civil damages in general. We got a very bad Supreme Court decision 2 years ago, where they say the court doesn't deny that the statute of limitation doesn't apply to these cases, but the court said that Argentina has a reparation program, so victims could get regular labor or civil damages in court because we have another reparation program. That's terrible because they are not looking that access to justice is denied by this kind of jurisprudence. But still we have pending of decision in the Inter-American Commission of Human Rights, a civil damage case is against Ford, and we are hoping to have a decision very soon because it's under the friendship procedure. So it's like a speed up procedure in the Inter-American Commission. And we have off the record information that the government, the national government is going to give allow civil reparations. So let's see about that. We also have the new civil code in Argentina, which established that the statute of limitation doesn't apply to damages related to crimes against humanity. But the problem of testing that new civil code is that if you lose the fees, you pay the lawyers of the companies. So that's something that is holding back us to litigate because of the Supreme Court ruling last year. Pretty much that's my answer. Sorry for the time.
Great, thanks, Gabriel. Okay, Dan, we're giving you 90 seconds. Answer whatever you will.
Right, just the issue of settlements as opposed to going to trial, and that there have only been 2 cases. I mean, I'm not sure if that takes into account the glorious victory of Friends of the Earth Europe against Shell in the Netherlands, which is a totally groundbreaking judgment. But it to my mind, that misses the point entirely, that analysis, because in fact, there've been lots and lots of jurisprudence that's been created. If you're a litigator in this realm, a lot of cases settle. What's our objective? Is it to go to trial, or is it to get remedy for victims? You know, if you sit down with the victims, if you talk about what they want, and someone's husband has been killed, someone can no longer work, they want remedy. And part of that remedy is to be able to continue living and to have a livelihood. So I would, strongly argue that there is actually tens of thousands of victims have been helped through these cases, and it's growing. And a lot of principles have also been established through Supreme Court decisions. So yes, I mean, you get a lot of settlements, but you're also getting settlements because they are on terms which are hugely beneficial, which give victims remedy for really serious human rights abuses. And I think that's something we shouldn't turn our nose up at. I know you've got to go, so I'll stop there.
Thank you, Dan. I wish maybe next time we could make this into like a 3-hour panel. This was so good. And I didn't even tell you all my questions. I have so many other ones. This was really fun. Thank you so much for doing this, Gabriel, Miriam, and Dan. I really hope we can do this again. Manal, I'm sorry that we're running late. So thank you, everybody. And everyone go to the Gwen Skinner thing, which is like right after this. But Manal, I'm going to pass it to you.